Hey guys, this is Todd King with the Accident Recovery Team. Welcome to another Facebook Live. It's Friday. The title of this one, I don't remember the exact title we put on there, but what I want to give you is some insight into what to expect in a work comp case, how it really works behind the scenes and how the system works. Not really about the value of a case, although we'll talk about that a little bit because every case is different when it comes to the potential value in a case. There are cases that are worth $1,000, there's cases that are worth $1 million. And no, yours probably isn't the $1 million case, but they do happen. We have had them, we've been successful in that, but most aren't, and there is a range in there of kind of an average, but I can't tell you what your case is unless we know the value of, we know the facts about the case, and even then we don't know until we move through the system in terms of what kind of disability you're going to have, what kind of pre-existing conditions you have, the value of wage loss or task loss as those things develop. So this is not about what to expect in terms of the value of a case. What it's about is what to expect in terms of if you have an attorney involved or you don't have an attorney involved, or if you do and you're in the system, what the system requires for you to go through to flesh out the case and maximize what benefit you can get out of it. I had to fire a client, and that doesn't happen very often, and we don't like to do that if we don't have to do that. And this is not a rant on a client, so don't perceive it that way, but it did bring to light for me something that I think is worth talking about, which is the kind of expectation of what the system provides. So I wanted to go over that and make that our topic today. But first, let's back up. So you get hurt at work, and you're dealing with, first of all, the employer either accepts to turn it into their work comp insurance or they don't. If they refuse to turn it into their work comp insurance, you don't have a lot of option other than to seek our assistance, or somebody like me to seek assistance. If they do turn it into the work comp insurance, and the work comp insurance accepts the claim, then your option is to follow through with what the work comp system is going to voluntarily do for you and accept that as that's sufficient, or to challenge that. From my experience in doing this for the last 20 years, is that many people will think that the insurance company is involved now and they are sending me to a doctor, and therefore I must be getting what I'm entitled to get. And the answer to that is maybe, maybe not. By the time people come see me and I have a consultation with them, consultations are free, of course, so we have a lot of people that take advantage of that. They find out that they're entitled to more than what they're getting, and the insurance company was not upfront and forthright about that. Also, when people treat to the end of treatment, there are sometimes they believe or are told to believe that that's all they're entitled to is treatment, and that's the end of the case. And many times communication with the insurance company will stop at that point. For every 10 people that the insurance company chooses to abandon or ignore at that point, 4 or 5 out of 10 will accept that, either unknowingly or begrudgingly, but they will accept that and walk away. They may not be happy about it, but still, the insurance company just saved money because 4 or 5 out of the 10 people that they might ignore didn't cost them anything after that. The remaining people that choose to seek assistance and understand that there's more that they are entitled to by law, that we have an opportunity to meet with and help, those people can then move through the system and ultimately recoup more benefits, future medical rights, additional compensations that the insurance company did not voluntarily provide for them or even let them know was available to them sometimes. So your best case scenario without counsel is that you have an insurance company that provides treatment to you, and then maybe at the end offers you a settlement. That settlement will be based solely on what their doctor said was your final impairment rating, or what represents the extent of your injury according to their doctor's opinion. They will then calculate that math and tell you what the formula is to calculate the dollars, and they'll tell you that's the settlement. First of all, that's never a good settlement. You don't know if that impairment rating is correct. You don't know if that math is correct. and very rarely are they ever going to voluntarily offer additional benefits or future medical rights or rights to review and modification that go along with that kind of a settlement. So your best case scenario is they've made you some sort of an offer, you've accepted it, your case is over, you have some money in your pocket. Not a good settlement most likely, but it was over and it was over fast. Your worst case scenario is the insurance company has walked you through it, they've treated you, and then they've abandoned you, and communication has stopped and you walk away. You have no further rights, you never got compensation. That maybe is your worst case scenario, assuming they've volunteered to treat you at all for your injury. So let's flip it to the other side of the coin. When you get an attorney, what happens here, when somebody comes to see me, the first thing I have to analyze is, can I be of benefit to them? There is no question that I can make a case worth more money. What I have to analyze is if they've been offered some money already, by the time I get paid, is the client still receiving more money than they would have before? Because if somebody comes to me and I say, look, by the time you pay me, you're back to where you started, we're very upfront about that. You maybe don't need me. But in that consultation, if we talk about not just the money, but other issues such as future medical rights or review and modification rights or certain reimbursements for expenses that they were never reimbursed for, mileage reimbursements, maybe there is a whole different category of compensation. Maybe there's a work disability element that no one has addressed, not just for the physical damage, but maybe there's economic damages in play that were never addressed. So when someone comes to see me, I have to look at, can we make them better off than they were without us? The answer is almost always yes. But we also then want to say, if we're going to move through the system, this is where we're coming into this realistic expectations part. And again, I'm not talking about dollars. I'm talking about realistic expectations and understanding some of the emotion that goes behind this. Because when somebody's injured or they're off work, well, they're in pain and they need money. And those are frustrating things that we deal with every day at the office. So I wanted to walk you through some of the things. I have clients that will call after seeing the insurance company doctor, and they are upset because the insurance company doctor has said something that they don't like, the diagnosis or the course of treatment, or the doctor didn't believe me about this or that. And they're emotionally involved in that information. And what we have to tell them is, or what I want you, our friends on Facebook, to understand is, from a realistic expectation standpoint, a couple of things. One, there are injuries for which you cannot be fixed. And we will walk you through the very best treatment that we can get for you and ultimately seek compensation for the extent of the injury and all of the other things that are available to us. Every tool that we have would be at your disposal. But some clients wrestle with this idea that sometimes you have an injury that can't be fixed, and that's emotionally difficult. If you have a significant injury, what I'm telling you is one realistic expectation to have as you start a case like this is to understand that we will seek all the treatment we can. We will try to get every doctor we can involved to fix it, but some injuries cannot be fixed. You might get to the end of treatment and still have some residual problems that have to be addressed long term. There are pain management issues, long-term management issues, future medical issues that have to be addressed when we get to the end of treatment and you're not at 100%. So emotionally, mentally, that's something that I counsel my clients to prepare for sometimes. Aside from that, I sometimes tell my clients when they're getting ready to go see an insurance company doctor, a new one or a specialist or something that the court has instructed to happen, that they may not like what they hear, and I want them to not be upset by that. I want them to understand that that is a doctor's opinion. He is entitled to that opinion. And the way that we combat a doctor's opinion is not for you to have to argue with him. That's something for us to deal with. I don't want you to deal with the doctor in terms of being upset, having an argument. The doctor's entitled to his opinion. We will seek out a second medical opinion. We will challenge the doctor for doctor. We'll go in front of a judge to address those disparities of opinion. But I want my client to have the reasonable expectation that you will hear things from insurance company appointed doctors that you don't want to hear. I don't want you to invest in it emotionally. We want you to let us take care of it. The other thing is, every case that we deal with, obviously there's an insurance adjuster out there. There's an attorney on the other side out there. They are going to say things. They're going to perhaps put surveillance sometimes on a client. they're going to make accusations against a client. They're going to come take a deposition and ask questions of my client. One expectation that I want my client to understand is that that's part of this process. They want to know your medical history. They want to know if you filed a work comp case before. They're not trying to villainize you, but it is part of the process. So I have clients that get upset because they feel like, hey, I'm the one that's been hurt here. I'm the one that needs the treatment. I'm the one that's off work. And now everybody's acting like I'm the bad guy, and that's how it feels. And I'm not saying you're not entitled to feel that way. I'm just saying that I want you to have a reasonable expectation that that will happen, and that is part of the claim. It's something that I tell you in advance as your attorney, as we move through it, that those kinds of things will happen. And again, I don't want you to be angry, because that doesn't help the process. What helps the process is, if they're inquiring, if they're seeking into your background, what we want to do is provide additional information. We want to address those concerns, bring in witnesses or medical records or whatever it is we need to do to narrow it down to a specific fact question or legal question that the judge can answer. So a realistic expectation for you as a potential client would be to understand that those are the kinds of questions that will be asked of you. Another one are judges. When we're in front of the judge, when we're in the courtroom, when we finally get there in the courtroom, and we may go multiple times. I have clients, this is very rare, but I have clients that will sometimes be upset with a judge or the judge's decision about when to address an item or what the judge does in addressing an item, how the judge rules on a decision. And I have clients that will sometimes say, well, that judge didn't care about me. That judge made the wrong decision, or that judge didn't listen to our evidence, or whatever it is. But we are frequently victorious in the courtroom. So I'm talking about anomalies. I'm talking about situations that don't happen very often. But when they do, I have a client that feels that maybe there was not equity or justice from the bench. And in that instance, again, this is something, an expectation that you'd have to have, is that if you have a work comp case and we're walking you through this process, you got to understand that we're going to have multiple fights along the way. We will have multiple hearings along the way. And you don't want to lose sight of the war over one battle. So if you have one preliminary hearing in which the judge denies one thing, I counsel my clients to have an expectation that you may have 8 preliminary hearings on our way to trial. And if you have a decision from a judge or an attitude from a judge that you didn't perceive was fair, I don't want you to be emotionally invested in that either, because we have a process to deal with it. We can come back and present additional evidence. There are appeals for preliminary hearings, or by the time you get to trial and you win the big picture, sometimes you pick up those things that at the preliminary stage you didn't like the result from. So a realistic expectation is that the judges are objective. I really don't have any complaints over these judges. Most of them are very objective. Most of them are very fair. But they are listening to 2 different sides, advocating 2 different positions. And many times they will compromise. And so sometimes what you may perceive as a loss is not, it is a compromise, and the judges do that. Sometimes the judge will continue a hearing or postpone a hearing or hold back on a decision pending an exam from another doctor. Again, that's a delay on my client's part, but it is part of the system that the judge is using. It's a tool the judge uses ultimately to seek out the right answer. So while we're on that point, the timeline. From the time that a client tells me, I've got a problem and I need to get that problem in front of a judge, I first have to get evidence to support whatever our argument is. If I have to send somebody out to a doctor to be examined in order to obtain a medical opinion that I have to put in front of the judge, you're looking at 2 or 3 weeks, sometimes more, to get into the doctor, get an examination, and get a report back to me that I can present to a judge. From the time I notify the court that we want to have a preliminary hearing over a particular issue, you're looking at about 30 days for the court to give us access to the court, a date for a court date. Now, knowing that a prelim is coming, we will many times request that prelim while we're still sending you out to see the doctor. We don't even have our report back, but we have confidence that we're going to get the evidence we need, and therefore we get to the court. So we try to expedite that by overlapping those efforts in scheduling. Once the judge receives the evidence in the courtroom, The judge has 30 days to make a decision. They rarely take that long, sometimes more, however. If the judge does render a court order, the other side has 30 days to comply with a court order. What that means is when the judge says, for the insurance company to pay my client needs the money, they want the money, they are entitled to the money, the judge has ordered them to be paid the money, they still have 30 days to comply with that court order. So this timeline becomes an issue. And again, I don't want to rant on a particular client, that's not what this is about. But I did have to fire a client, coming back to my initial comment. And this was a situation where they had submitted a mileage reimbursement. They're entitled to that reimbursement. The notion that they had to wait for a response from the insurance company, and if they refused, they'd have to go to court for me to force it to happen, to get a court order to make them get their reimbursement back, was unacceptable to this particular client. I offered that a court order could also order that transportation could be provided rather than have to go through the reimbursement process. That was not an option that they wanted either. And ultimately what it boiled down to is they were so frustrated by that having to wait that they were cussing and things like that to my staff, which is unacceptable, and that's what we don't tolerate. You can yell at me if you want to, but not my staff. And so we ended that relationship. But it's not a rant about those people. But they had a perfectly valid case. They had a case. They were ultimately going to get everything. They were going to get their settlement. They were going to get the treatment. But they didn't have a realistic expectation of a simple concept of how long it would take to get reimbursed for some mileage. And that frustration, it was something that boiled over for them. And so that flashpoint was just a time when I thought, you know, that is a good point for us to talk about on Facebook Live. Realistic expectations. Again, I can't talk about the value of cases because they vary so much depending on the facts. But what I can tell you is some other things to expect. If you are off work, you're entitled to a weekly benefit. That weekly benefit is supposed to be calculated as 2/3 of your pre-injury gross average weekly wage as averaged for the 26 weeks immediately preceding the date of accident. Did I lose you on that? That's complicated. But the point is, there's a mathematical formula for that. It's not about justice, it's not about equity. There is a mathematical formula set by statute on how to calculate that. My clients rightfully point out, well, my bills don't change. That's true, we understand that. And yet they're going to be making less money while they're off work than if they were getting wages. I understand that too, but the law is the law. I can't change that figure. There are also caps in place. $610 per week would be a cap no matter what your wages were. If 2/3 of your pre-injury gross average weekly wage is $800, you're still only going to get $610. You see how this spirals. Financially, they still have the bills. They still have all those obligations, and yet there are these statutory limits. That's an expectation that I make sure my client understands at the beginning of the case coming in. Because of that, we want our client back to work. Our client wants to get back to work. No one's making a killing. No one's making a windfall of money by being off work for a work comp injury. They want to get back to work. The other thing is the caps that are in place in terms of the settlement that you can get on a case. There are caps in place for the total amount of money that one can receive for both the settlement and the off-work pay combined. And that is $130,000 over the entire course of the case. Off-work benefits and the final settlement total will not exceed $130,000. There's another category, though, that refers to permanent total disability. Permanent total disability means your injury has rendered you completely incapable of substantial gainful employment. Meaning, not only did I lose this job, but I can't work at any job. If the injury is that significant, that maximum amount is bumped up to $150,000. Death cases, $300,000. But there are these caps locked in place. So you ask me, well, then how do you win $1 million case? Well, we won $1 million case because the one thing that's not capped are medical rights. You can get medical treatment for your life, provided that the judge awards it to you at the time of the final award and that you actively continue to use that. There are situations where we settle out that future medical in exchange for compensation, for money. So if you don't want to be locked into the work comp insurance doctors for the rest of your life, you want to go to the doctor you choose and when you want, you can sometimes negotiate a cash settlement of the future medical rights for which there is no cap. But otherwise, not counting the future medical part, there are these caps built in place in terms of what you can get per week, what the total amount of the settlement or the entire value of the case can be, not counting medical bills. So the realistic expectations does include some sort of monetary limitations as well. But really the point of my discussion today had more to do with understanding the timeline, understanding that it takes time to make a demand, let the insurance company respond to that, and if they don't, you take them into the courtroom, you get an order, they have to comply with the order. We can't talk settlement until you're done treating, so we have to wait through the course of treatment before we can get a final assessment done as to your physical injury or any economic damages resulting from it, before we can move to a settlement conference, before we can move to a trial. I'm not trying to bore you today with the details of what these steps are. I am illustrating to you that there are these steps. So you look at that and say, well, then why would I want to participate in all of this? And the answer is because you only get one shot. You only get one shot at this case to do it right. That settlement that you may be offered, if you're one of the lucky 5 out of 10 people that they make you an offer at all, if you accept it, that was not a good deal. Over the course of a few months, you may be able to maximize the dollar figure, you may be able to account for all reimbursements, you may be able to account for economic damages, you might be entitled to future medical rights, and lock in the right to review and modification in case your condition changes in the future. You only get one shot to do it right. You want to do it right, we want to help you do it right. So every client that comes in, I give them this little talk about expectations on how this works, what we're going to go through. So that when they sign up, they understand these things. They understand as we move through what each step's going to be. They don't always remember it as we're going through, and we remind them, but we do tell them as we start. So there you go, Facebook Live on expectations of what the work comp system is going to be like as we move through it. If you have questions, you can leave it on the comments below, or you can give us a call at 267-TEAM. Of course, you can find us at accidentrecoveryteam.com or 267team.com. Give us a call if you have any questions. Thanks. Bye.